Now we cross live to our studios in Cape Town to Ghalib Galant, the Deputy National Coordinator of Right to Know. Thank you for being with us, Mr. Galant. And this is an interesting one. Do you feel that this is about the President trying to hide information that we should know about? He shouldn't have anything to hide. Or is it fair enough? He's saying confidential information is obtained in bank statements. We don't know how those bank statements were obtained by the Public Protector. Therefore, we don't have a right to know.
So I guess evening, Francis. I guess the challenge is that we're balancing two rights here: the right to privacy, and that's contained in the Protection of Personal Information Act, and then of course the right to the public to have insight into, for example, how our public officials get their money. And particularly around election processes. But I think it's a little bit more complicated than that. In terms of what I understand, the President's lawyers are arguing that the POPI Act says some of the information may have been, first of all, needs to be kept confidential. That's one piece. So the operation of that act requires any entity that gets personal information to manage that carefully. So there's the question around how information personal to third parties particularly, but even to Cyril Ramaphosa, needs to be handled. And that includes the bank statements, etc. Then there's an evidentiary question around how the information was gotten. And that then opens up a whole other can of worms around whether one can rely on improperly obtained information. And particularly if you're wanting to pursue, as the Public Protector has indicated, criminal charges, where the quality of the information will lead to whether or not a successful prosecution can follow. So that's the one side. The public certainly has an interest in where political parties get their money. Here we are dealing with the internal elections of a single political party, and we've just passed the Political Party Funding Act. We're in the process of compiling regulations now about how information about elections and party funding will be disclosed to the public. So we have a deep interest in that. Having said all of that, I think we must remain cautious, because probably what we're seeing here is also quite problematic for us at Right to Know. What we're seeing, it feels like, is a political factional battle. And so the information that we would be interested in isn't just the President's internal election campaign funding, but it would have been all of the candidates that stood for ANC President at Nasrec. So I think we've got to be very careful.
Sure. I think in the arguments, in the legal arguments, his lawyers at one stage were suggesting that the law is very quiet, not on campaign funding, not on party funding, like you say, that's been a debate for years, but on funding to an individual inside the campaign. Let's start there. Is the law quiet on that? And then he also complained that he would be at an unfair advantage. It sounds like you're agreeing with that if only his records come out. Sorry, at disadvantage,
so I think, So I think a reading of the Public Funding Act and the regulations that have been offered by the IEC, the Act, for example, says no member of a political party may accept donations except for a party political purpose. And so an internal election would be a party political purpose. That means we believe that the IEC ought to have insight into monies given to internal candidates in election battles as well within the party. So I think the law seems to be quite clear on that aspect, and even in the public submissions on the regulations, even the political parties seem to have conceded that as currently drafted, the Act allows for those campaign contributions to internal campaigns also to be made public. But the problem we're sitting with here is that it is only one side of that internal campaign.
Yeah.
It isn't, so it isn't all of the candidates. So we don't know, for example, how much the NDZ campaign managed to accumulate.
Mr. Galant, going back to my first question, and very quickly, if you don't mind, should a president committed to transparency and openness care how these were collected? Should he not say, I don't mind if it's going to be public? Or is he raising a valid argument?
So I'm not quite sure that that's the argument that he's making. It sounds like what they're wanting to keep confidential is information of third parties. So this is not so much about his own personal information, but potentially damaging or revealing information from third parties. And that's where we get into what the provisions of the POPI Act requires. Also, even the public protector in this case, to be respectful of.
All right, thank you very much. That was Ghalib Galant, the Deputy National Co-ordinator of the Right to Know campaign. We also have Ralph Mathekga on the line, a political analyst. Ralph, thank you for being with us. This is an interesting one. Do you agree it's about third-party information? The president isn't necessarily being dodgy, trying to hide information here.
Good evening, dear viewers. I think that, look, legally, when it comes to legalities of this, the president has got the right to demand that the information is held confidential and so forth. But politically, I think it's a no-go area for the president. I mean, it is really very interesting to see the president now not only failing to voluntarily talk more or give more details about his donors, but now going out of the way to try to make sure that this remains a secret. I mean, it raises serious questions about the president's commitment to, openness and transparency. He's now coming out as someone who it's quite evasive. I mean, he has not dealt with this issue very well. But now this is a serious twist of when the president wants to maintain that information should be sealed. Now it's quite a twist that actually shows that the president seems not to be willing to voluntarily provide more information on this campaign funding.
He's also speaking about the leaked emails, reportedly showing that he wasn't actually at an arm's length. He maybe knew about a lot of the funds coming in and out of those accounts, donor funds specifically. Is he right to object that they weren't given to him? Or in the same vein, why is he so worried if what he said initially was true?
The thing is that it looks like now he's being careful as to which information is available to the public about that. It appears that he seems to have a position that he wants to sustain on this. And the reality is that if this will not really succeed, I mean, you cannot seal that information. And I think that if people realize that we are making effort to hold things confidential in this regard, it does raise questioning to why is it that we are so committed to keeping this information away from the public eye. It just doesn't sit well with someone who actually said that they're going to do things differently. They believe in transparency and accountability. It makes this issue even bigger than it initially was, the whole issue of the campaign finance.
But the whole point is it's statements linked to a whole lot of companies. It seems I don't know enough information about the bank accounts that are not Cyril Ramaphosa's foundation. So could there not be an argument here of protecting third-party information?
It can be made. I mean, legally, yes, the president legally can say he is obligated to protect those third parties to make sure we do not know. But politically, really, it's really questionable that now the president one does not to know to protect those parties and to go out of the way to protect those parties. It raises the concern as to why would you accept the money of people you wouldn't know the general public to actually know about. Remember, at the core of this thing, when it comes to campaign financing, it's political leaders. Why would you accept the money that you would not be willing to stand openly next to the donor in the public? This comes down to that.
All right, so you're concerned about the president's transparency. What about the public protector? The president suggesting she obtained some bank account information, possibly illegally. How serious would that be for her?
I mean, first of all, the information is out there. It is already of public interest that this information is out there. Of course, we are asking questions as to how was the information acquired. I do believe that if there is a suspicion that there's been wrongdoing in how that information has been obtained by the public protector, if there one can sustain the charge that the public protector might have acquired that illegally, then there are proper mechanisms that has to be taken. There are laws stating how information needs to be accessed in South Africa. If that was obtained through the intelligence as well, in proper manner, it's unacceptable. And be that as it may, that can be investigated separately, but still the question as to the substantive matters, as to the need for transparency on the side of the president, the need for the president to disclose, that still remains a defensible, I would say, position, that even if we need to investigate, even if there might be a need to investigate the source of this information, the president politically has to respond to the content, which is his campaign finance, as to who funds it.
Sure, I hear you. And final question on her side, is this something that Parliament could act on if the banks say no, there were no subpoenas served, they didn't hand over the information?
Another point as well is whether that information, I mean, we're saying that information was attained illegally. We don't know if maybe someone made it available to the public protector. We don't know. Hence, an investigation will be quite necessary. But also, again, out of public interest, the question is, would it be possible should it be required of the public protector to access this kind of information if you are doing an inquiry into that? For me, the answer is yes. It's incidental. If you're going to investigate, to do an investigation of this nature, you need access to this kind of information, and you need to acquire it properly, no doubt. But I think that information itself, for me, it's quite material in an investigation that might involve party funding. Remember, the whole thing started with an innocent case of Busisiwe. Now it's getting bigger and bigger.
All right, Ralph Mathekga, a political analyst, thank you very much for being with us tonight. And like he says, it's a piece of more questions than answers around this issue tonight.